Welcome back to Outside Views, and this is a story about how my life got twisted upside down. No, not that one. This is a story about the messy, tedious, and utterly predictable consequences of a massive political decision, and how years later, lawyers and businesses are desperately trying to glue back together the legal infrastructure that reckless nationalism shattered. And the topic today is cross-border dispute resolution after Brexit, and specifically the role of the Hague Convention on the recognition and enforcement of foreign judgments in civil or commercial matters, the HCCH 2019 Convention. And my strong personal view is that the very fact we are celebrating the entry into force of this obscure legal mechanism is a devastating indictment of the Brexit project itself, because this convention is merely a patch on a gaping legal wound that never needed to exist. Brexit, in its political delusion, destroyed a seamless, efficient and comprehensive system of legal cooperation that had been built over decades, the Brussels 1A regulation, and replaced it with a patchwork of treaties that are more complex, more limited and less effective. And the fact that this new Hague Convention came into force in the UK on July 1st, 2025 to close a Brexit-regulated regulatory gap is the clearest admission that leaving the EU was a mistake that fundamentally compromised the legal security of international business. The cost of this legal chaos is immense, but it is entirely attributable to the political choices of the Brexiteers. The core political failure here is one of colossal intellectual laziness and willful denial. The proponents of Brexit operated under the fantasy that the UK could simply discard the bad parts of EU membership, like political bureaucracy, while magically retaining the good parts, like frictionless trade and seamless legal enforcement. The Brussels 1A regulation was the gold standard for recognizing judgments across the EU, making London an unparalleled hub for commercial litigation. And this system was not some peripheral EU directive. It was the bedrock of legal certainty that underpinned billions of pounds in cross-border commerce and sustained the competitiveness of the UK's legal services sector. The Brexiteers' lack of foresight meant they failed to understand or simply chose to ignore that the Brussels 1A regulation was interdependent with EU membership. And they believed that because the UK was a sovereign state, it could simply ask to rejoin the system or that the EU would consent out of goodwill. And this naive belief was a profound political miscalculation. The central argument for leaving was framed as taking back legal sovereignty from the European Court of Justice, or ECJ. But the ECJ's role was the price of seamless enforcement, acting as the ultimate guarantor of uniform interpretation across all member states under the Brussels regime. And when the UK government ruled out any role for the ECJ, it unilaterally slammed the door on the Brussels 1A regulation. And this failure to plan for a realistic legal replacement is the single greatest indictment of the entire movement. Lord Thomas of, and I'm here hanging on the Welsh, is it Mead, warned that after leaving the UK would be a relatively small jurisdiction set between two very large jurisdictions, the United States and the European Community, and that its ability to influence the fashioning of the law would be drastically reduced. The subsequent rejection of the UK's application to rejoin the Lugano Convention, a similar if less comprehensive regime shared with Norway, Iceland and Switzerland, simply confirmed that the political project had trumped legal sense. And this rejection solidified the Brexit enforcement gap, forcing the UK to scrabble for alternatives. Instead of being a world-beating legal hub, London was relegated to joining an international convention that serves as a minimum standard and not a premium solution. Before Brexit, for businesses trading across the Channel, legal certainty was almost absolute. If a business in London sued a client in Paris and won, the judgment was recognized and enforced almost automatically under the Brussels 1A regulation. And this mechanism was quick, cheap, and robust, and it covered both the issues of jurisdiction where you could sue and enforcement, making the other side pay. Brexit threw all that out of the window, immediately adding friction, cost, and risk to every single contract between the UK and the EU. The Brussels 1A regulation vanished for the UK, and in its place, they got a period of legal uncertainty that was an absolute nightmare for lawyers and companies alike. The current situation relies on two key Hague Conventions, but they are not equal replacements. First, there is the Hague Convention on Choice of Court Agreements, the HCCH 2005, which the UK rejoined independently. This is useful, but it's limited. It only applies when parties have agreed to an exclusive jurisdiction clause in their contracts, meaning they must use a specific court. But what about contracts with non-exclusive or asymmetric jurisdiction clauses, or where no jurisdiction was specified? What about judgments based on non-contractual claims like negligence? For those, the HCCH 2005 Convention is useless. And this is where the new HCCH 2019 Convention, or HAVU, as a German letter, as it's known in Germany, is supposed to ride to the rescue. But while it promises time and cost-efficient enforcement, it does so with significant caveats and massive holes. The HCCH 2019 Convention is a welcome development only in the sense that having a limited tool is better than having no tool at all. It covers judgments in civil and commercial matters, which is good for basic contractual disputes, for debt claims and collective actions. And it specifically applies to decisions on the merits, including default judgments and certain interim payment orders. However, it immediately creates new problems simply by not being the Brussels 1A regulation. Crucially, the HCCH 2019 Convention provides no rules on international jurisdiction or on coordinating parallel court proceedings. And this is a massive deficiency. Under the old EU rules, if a UK company sued an EU company in London, the EU courts were largely obliged to stand down. Now, jurisdiction is determined by the messy and often conflicting national laws of the court first approached. And this immediately increases the risk of parallel proceedings where two parties sue each other in different countries simultaneously, leading to wasted legal fees and conflicting results. And this is the true cost of lost cooperation. A predictable system has been replaced by an expensive race to the courthouse. And furthermore, the scope of the HCCH 2019 Convention is riddled with exclusions that highlights its limited effectiveness. The most important exclusion, which we are all seamlessly covered by the Brussels 1A regulation, are the insolvency matters, for example. Decisions concerning bankruptcy, insolvency proceedings, or similar arrangements are excluded. And this is a huge gap for any company with cross-border liabilities or supply chain issues. And then the intellectual property matters. While decisions on general contract law like royalty fees under a trademark license are covered, decisions concerning the validity, registration, or infringement of intellectual property rights are excluded. And this means a judgment on a major patent or copyright infringement from a UK court cannot automatically be enforced in the EU. And there's arbitration. Decisions related to the enforcement or setting aside of arbitral awards are excluded, though this is partially covered by the separate New York Convention. And then there's certain competition law matters. While decisions on hardcore cartels may be covered if both the conduct and the effect occurred in the originating state, prohibitions and restrictions on unilateral conduct, like abuse of a dominant market position, are generally excluded. And this means for large, complex commercial disputes, the kind that truly matter for global companies, the system is still fragmented and reliant on national laws, where enforcement is a slower and more difficult process. The HCCH 2019 Convention is only applicable if one of its specific jurisdictional grounds is met, such as the defendant's ordinary residence or place of business in the originating state, or if the defendant expressly consented to the jurisdiction or entered an appearance without contesting it. And this is the core legal cost of Brexit. A simple, comprehensive system has been replaced by a complicated conditional mechanism. And I'm quite sure in the details I lost a few viewers, at least from their ability of following me. And that shows it all. And the insult to legal practice is that the entire process of enforcement under the HCCH 2019 Convention is, by its very nature, a step backwards. And under the Brussels 1A regulation, recognition was virtually automatic. Under the new convention, the enforcement court, whether it's a Landgericht in Germany or a high court in the UK, still has to go through a checklist. And while the substantive review of the original judgment is prohibited, they can't retry the case, they must check for grounds for refusal under Article 7. And these refusal grounds are thankfully narrow, things like breach of public policy or the defendant not receiving proper notice. But the need for this formal process, which required certified copies, sworn translations into the official language of the requested state, and an application under national law, adds time and cost. And it's an administrative and legal hurdle that simply did not exist before the political decision to leave. And the fact that UK companies now have to concern themselves with details like the German AVHG, which I didn't mention earlier for some reason of complexity, or specific sections of the UK's own Civil Jurisdiction and Judgments Act of 1982 to understand how to collect the debt across the channel, is a monumental waste of highly skilled legal resources. And the UK government may trumpet the deal with Switzerland, which is now one of the likely destinations for corporate HQs leaving the UK. But for the vast majority of cross-border trade, the EU relationship is what matters. And in that essential relationship, the legal machinery is now slower, more expensive, and less reliable. The HCCH 2019 Convention is necessary only because the Brexiteers chose to smash the existing infrastructure. And the consequence for internationally active companies is profound. They now have to engage in careful, difficult trade-offs when drafting contracts. Do they opt for an asymmetric jurisdiction clause, which might force them to rely on the HCCH 2019 Convention, plugging a critical gap left by the HCCH 2005? Or do they choose arbitration, which is expensive and excluded from the convention scope, but it offers its own distinct enforcement benefits? For example, where I'm living, the German procedural requirement for security for costs is even waived in cases falling under the HCCH 2019 Convention. That's a small benefit, but one that highlights the need for a complex legal framework just to regulate what was once simple. And this entire development is a clear and documented setback for the legal profession and for businesses operating between the UK and the EU. It's a victory for complexity over efficiency, a victory for bureaucracy over common sense, and it's entirely attributable to the political anti-cooperation ideology of Brexit. And people should not be celebrating the arrival of a restrictive patch-up convention. They should be mourning the loss of a seamless legal certainty that the UK foolishly discarded. And the core lesson here is that the simplicity and efficiency of the Brussels 1A regulation, a system built on shared trust and integrated law, could never be fully replicated by a treaty which is inherently limited and negotiated for the lowest common denominator. The Brexiteers promised legal sovereignty, and what they delivered was legal complication, costing businesses time, money, and certainty. And the political failure lies not in the small print of the HCCH 2019, but in the catastrophic lack of foresight that required the Brits to resort to it in the first place. And if you want to know more, the next video is right here in the end screen.